Short title. This act may be cited as the Bills of Exchange Act 1882. Two, interpretation of terms.
You can go faster.
In this act.
900 words per minute.
Bankruptcy. Bearer means the person in possession of a bill or note which is payable to bearer. Bill means bill of exchange, and note means promissory note. Delivery means transfer of possession, actual or constructive, from one person to another. Holder means the payee or endorsee of a bill or note who is in possession of it, or the bearer thereof. Endorsement means an endorsement completed by delivery. Issue means the first delivery of a bill or note, complete in form, to a person who takes it as a holder. Person includes a body of persons, whether incorporated or not. F1 postal operator has the meaning given by F2, Section 27 of the Postal Services Act. Value means valuable consideration. Written includes printed, and writing includes print. Textual amendments F1S. 2. Definition of postal operator. Inserted March 26, 2001 by SI 2001 1149 Art. 3.1 1 para. 4.2 F. 2 words in S. 2. Substituted January 10th, 2011 by Postal Services Act. 12 para. 73 SI 2011 2329 Art. Modification. 2. Local. Part 2. Bills of Exchange. Form and interpretation. 3. Bill of Exchange defined. 1. A bill of exchange is an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or to bearer. 2. An instrument which does not comply with these conditions or which orders any act to be done in addition to the payment of money is not a bill of exchange. 3. An order to pay out a particular fund is not unconditional within the meaning of this section, but an unqualified order to pay, coupled with A, an indication of a particular fund out of which the drawee is to reimburse himself, or a particular account to be debited with the amount, or B, a statement of the transaction which gives rise to the bill, is unconditional. 4. A bill is not invalid by reason A, that it is not dated, B, that it does not specify the value given, or that any value has been given therefore. 3. C, that it does not specify the place where it is drawn, or the place where it is payable, modifications, etc., not altering text. C. 3S. 3. Amended by Decimal Currency Act 1969 C19 S2 for inland and foreign bills. 1. An inland bill is a bill which is, or on the face of it, purports to be A, both drawn and payable within the British Islands, or B, drawn within the British Islands upon some person resident therein. Any other bill is a foreign bill. For the purposes of this act, British Islands mean any part of the United Kingdom of Great Britain and Ireland, the islands of Man, Guernsey, Jersey, Alderney, and Sark, and the islands adjacent to any of them being part of the dominions of Her Majesty. 2. Unless the contrary appear on the face of the bill, the holder may treat it as an inland bill. 5. Effect where different parties to bill are the same person. 1. A bill may be drawn payable to or to the order of the drawer, or it may be drawn payable to or to the order of the drawee. 2. Wherein a bill drawer and drawee are the same person, or where the drawee is a fictitious person or person not having capacity to contract, the holder may treat the instrument at his option, either as a bill of exchange or as a promissory note. 6. Addressed to drawee. 1. The drawee must be named or otherwise indicated in a bill with reasonable certainty. 2. A bill may be addressed to 2 or more drawees whether they are partners or not, but an order addressed to 2 drawees in the alternative or to 2 or more drawees in succession is not a bill of exchange. 7. Certainty required as to payee. 1. Where a bill is not payable to bearer, the payee must be named or otherwise indicated therein with reasonable certainty. 2. A bill may be made payable to 2 or more payees jointly, or it may be made payable in the alternative to one of 2 or one or some of several payees. A bill may also be made payable to the holder of an office for the time being. 3. Where the payee is a fictitious or non-existing person, the bill may be treated as payable to bearer. What bills are negotiable? 1. When a bill contains words prohibiting transfer or indicating an intention that it should not be transferable, it is valid as between the parties thereto, but is not negotiable. 2. A negotiable bill may be payable either to order or to bearer. 3. A bill is payable to bearer, which is expressed to be so payable, or on which the only or last endorsement is an endorsement in blank.
Blank
A
endorsement.
bill is payable to order, which is expressed to be so
Means you
payable,
sign it blank,
or
they
which is
fucking-
expressed to be payable to a particular person, and does not contain words prohibiting transfer or indicating an intention that it should not be transferable. 5. Where a bill, either originally or by endorsement, is expressed to be payable to the order of a specified person, and not to him or his order, it is nevertheless payable to him or his order at his option. 9. Sum payable. 1. The sum payable by a bill is a sum certain within the meaning of this act, although it was required to be paid. A. With interest. B. By stated installments. C. By stated installments, with a provision that upon default in payment of any installment, the whole shall become due. D. According to an indicated rate of exchange or according to a rate of exchange to be ascertained as directed by the bill. 2. Where the sum payable is expressed in words and also in figures, and there is a discrepancy between the two, the sum denoted by the words is the amount payable. 3. Where a bill is expressed to be payable with interest, unless the instrument otherwise provides, interest runs from the date of the bill, and if the bill is undated from the issue thereof. 10. Bill payable on demand. 1. A bill is payable on demand. A. Which is expressed to be payable on demand or at sight or on presentation, or B. In which no time for payment is expressed. 2. Where a bill is accepted or endorsed when it is overdue, it shall, as regards the acceptor who so accepts, or any endorser who so endorses it, be deemed a bill payable on demand. 11. Bill payable at a future time. A bill is payable at a determinable future time within the meaning of this act, which is expressed to be payable. 1. At a fixed period after date or site. 2. On or at a fixed period after the occurrence of a specified event which is certain to happen, though the time of happening may be uncertain. An instrument expressed to be payable on a contingency is not a bill, and the happening of the event does not cure the defect. 5. 12. Omission of date in bill payable after date. Where a bill expressed to be payable at a fixed period after date is issued undated, or where the acceptance of a bill payable at a fixed period after sight is undated. Any holder may insert therein the true date of issue or acceptance, and the bill shall be payable accordingly. Provided that 1. Where the holder in good faith by mistake inserts a wrong date, and 2. In every case where a wrong date is inserted. If the bill subsequently comes into the hands of a holder in due course, the bill shall not be avoided thereby, but shall operate and be payable as if the date so inserted had been the true date. 13. Antedating and postdating. 1. Where a bill or an acceptance or any endorsement on a bill is dated, the date shall, unless the contrary be proved, be deemed to be the true date of the drawing, acceptance, or endorsement, as the case may be. 2. A bill is not invalid by reason only that it is antedated or postdated, or that it bears date on a Sunday. 14. Computation of time of payment. Where a bill is not payable on demand, the day on which it falls due is determined as follows. F3. The bill is due and payable in all cases on the last day of the time of payment as fixed by the bill, or, if that is a non-business day, on the succeeding business day. 2. Where a bill is payable at a fixed period after date, after sight, or after the happening of a specified event. The time of payment is determined by excluding the day from which the time is to begin to run, and by including the day of payment. 3. Where a bill is payable at a fixed period after sight, the time begins to run from the date of the acceptance if the bill be accepted, and from the date of noting or protest if the bill be noted or protested for non-acceptance or for non-delivery. 4. The term month in a bill means a calendar month. Textual amendments F3S 14.1 substituted except in relation to bills drawn and notes made before January 16, 1972 by Banking and Financial Dealings Act 1971 C80 S 323. 15. Case of need. The drawer of a bill and any endorser may insert therein the name of a person to whom the holder may resort in case of need, that is to say, in case the bill is dishonored by non-acceptance or non-payment. Such person is called the referee in case of need. It is in the option of the holder to resort to the referee in case of need or not as he may think fit. 16. Optional stipulations by drawer or endorser. The drawer of a bill and any endorser may insert therein an express stipulation, 1. Negativing or limiting his own liability to the holder. 2. Waiving as regards himself some or all of the holder's duties. 17. Definition and requisites of acceptance. 1. The acceptance of a bill is the signification by the drawee of his assent to the order of the drawer. 2. An acceptance is invalid unless it complies with the following conditions, namely, A. It must be written on the bill and be signed by the drawee. The mere signature of the drawee without additional words is sufficient. B. It must not express that the drawee will perform his promise by any other means than the payment of money. 18. Time for acceptance. A bill may be accepted 1. Before it has been signed by the drawer, or while otherwise incomplete. 2. When it is overdue, or after it has been dishonored by a previous refusal to accept, or by non-payment. When a bill payable after sight is dishonored by non-acceptance, and the drawee subsequently accepts it, the holder, in the absence of any different agreement, is entitled to have the bill accepted as of the date of first presentment to the drawee for acceptance. 19 general and qualified acceptances. 1. An acceptance is either A, general, or B, qualified. 2. A general acceptance assents without qualification to the order of the drawer. A qualified acceptance in express terms varies the effect of the bill as drawn. In particular, an acceptance is qualified which is conditional, that is to say, which makes payment by the acceptor dependent on the fulfillment of a condition therein stated. B. Partial, that is to say, an acceptance to pay part only of the amount for which the bill is drawn. C. Local, that is to say, an acceptance to pay only at a particular specified place. An acceptance to pay at a particular place is a general acceptance, unless it expressly states that the bill is to be paid there only and not elsewhere. D. Qualified as to time, e. the acceptance of some one or more of the drawees, but not of all. 7. 20 inchoate instruments. 1. Where a simple signature on a blank FF4 paper is delivered by the signer in order that it may be converted into a bill. It operates as a prima facie authority to fill it up as a complete bill for any amount. F4. Using the signature for that of the drawer or the acceptor or endorser, and in like manner when a bill is wanting in any material particular. The person in possession of it has a prima facie authority to fill up the omission in any way he thinks fit. 2. In order that any such instrument when completed may be enforceable against any person who became a party thereto prior to its completion, it must be filled up within a reasonable time, and strictly in accordance with the authority given. Reasonable time for this purpose is a question of fact, provided that if any such instrument after completion is negotiated to a holder in due course, it shall be valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up within a reasonable time and strictly in accordance with the authority given. Textual amendments F-words repealed by Finance Act C. SPTV and Finance Act Northern Ireland C. SPT. 3rd. 21. Delivery. 1. Every contract on a bill, whether it be the drawers, the acceptors, or an endorser's, is incomplete and revocable until delivery of the instrument in order to give effect thereto. Provided that where an acceptance is written on a bill, and the drawee gives notice to or according to the directions of the person entitled to the bill that he has accepted it, the acceptance then becomes complete and irrevocable. 2. As between immediate parties and as regards a remote party other than a holder in due course, the delivery, A, in order to be effectual, must be made either by or under the authority of the party drawing, accepting, or endorsing, as the case may be. B may be shown to have been conditional or for a special purpose only, and not for the purpose of transferring the property in the bill. But if the bill be in the hands of a holder in due course, a valid delivery of the bill by all parties prior to him so as to make them liable to him is conclusively presumed. 3. Where a bill is no longer in the possession of a party who has signed it as drawer, acceptor, or endorser, a valid and unconditional delivery by him is presumed until the contrary is proved. Capacity and authority of parties. 22. Capacity of parties. 1. Capacity to incur liability as a party to a bill is coextensive with capacity to contract, provided that nothing in this section shall enable a corporation to make itself liable as drawer, acceptor, or endorser of a bill unless it is competent to it so to do under the law for the time being in force relating to corporations. 2. Where a bill is drawn or endorsed by an infant, minor, or corporation having no capacity or power to incur liability on a bill, the drawing or endorsement entitles the holder to receive payment of the bill, and to enforce it against any other party thereto. 23. Signature essential to liability. No person is liable as drawer, endorser, or acceptor of a bill who has not signed it as such, provided that 1. Where a person signs a bill in a trade or assumed name, he is liable thereon as if he had signed it in his own name. 2. The signature of the name of a firm is equivalent to the signature by the person so signing of the names of all persons liable as partners in that firm. 24. Forged or unauthorized signature. Subject to the provisions of this Act, where a signature on a bill is forged or placed thereon without the authority of the person whose signature it purports to be, the forged or unauthorized signature is wholly inoperative, and no right to retain the bill or to give a discharge therefor or to enforce payment thereof against any party thereto can be acquired through or under that signature, unless the party against whom it is sought to retain or enforce payment of the bill is precluded from setting up the forgery or want of authority. provided that nothing in this section shall affect the ratification of an unauthorized signature not amounting to a forgery. 25 procuration signatures. A signature by procuration operates as notice that the agent has but a limited authority to sign, and the principal is only bound by such signature if the agent in so signing was acting within the actual limits of his authority. 26 persons signing as agent or in representative capacity. 1. Where a person signs a bill as drawer, endorser, or acceptor and adds words to his signature indicating that he signs for or on behalf of a principal. Or in a representative character, he is not personally liable thereon, but the mere addition to his signature of words describing him as an agent or as filling a representative character does not exempt him from personal liability. 2. In determining whether a signature on a bill is that of the principal or that of the agent by whose hand it is written, the construction most favorable to the validity of the instrument shall be adopted. 9. The consideration for a bill. 27. Value and holder for value. 1. Valuable consideration for a bill may be constituted by A. Any consideration sufficient to support a simple contract. B. An antecedent debt or liability. Such a debt or liability is deemed valuable consideration, whether the bill is payable on demand or at a future time. 2. Where value has at any time been given for a bill, the holder is deemed to be a holder for value, as regards the acceptor and all parties to the bill who became parties prior to such time. 3. Where the holder of a bill has a lien on it, arising either from contract or by implication of law, he is deemed to be a holder for value to the extent of the sum for which he has a lien. 28. Accommodation bill or party. 1. An accommodation party to a bill is a person who has signed a bill as drawer, acceptor, or endorser without receiving value therefore, and for the purpose of lending his name to some other person. 2. An accommodation party is liable on the bill to a holder for value, and it is immaterial whether, when such holder took the bill, he knew such party to be an accommodation party or not. 29. Holder in due course. 1. A holder in due course is a holder who has taken a bill, complete and regular on the face of it, under the following conditions, namely, a. That he became the holder of it before it was overdue, and without notice that it had been previously dishonored, if such was the fact. B. That he took the bill in good faith and for value, and that at the time the bill was negotiated to him, he had no notice of any defect in the title of the person who negotiated it. 2. In particular, the title of a person who negotiates a bill is defective within the meaning of this act when he obtained the bill, or the acceptance thereof, by fraud, duress, or force and fear, or other unlawful means, or in illegal consideration, or when he negotiates it in breach of faith, or under such circumstances as amount to a fraud. 3. A holder, whether for value or not, who derives his title to a bill through a holder in due course, and who is not himself a party to any fraud or illegality affecting it, has all the rights of that holder in due course as regards the acceptor and all parties to the bill prior to that holder. Modifications, etc., not altering text, C 4S 29, excluded by Consumer Credit Act 1974 C 39 CIF 60 S 125 1 C 5S 29 2, amended by Consumer Credit Act 1009, amended to 74 C 39 CIF 60 S 125 2. 30. Presumption of value and good faith. 1. Every party whose signature appears on a bill is prima facie deemed to have become a party thereto for value. 2. Every holder of bill is prima facie deemed to be a holder in due course, but if in an action on a bill, it is admitted or proved that the acceptance, issue, or subsequent negotiation of the bill is effected with fraud, duress, or force and fear, or illegality, the burden of proof is shifted, unless and until the holder proves that, subsequent to the alleged fraud or illegality, value has in good faith been given for the bill. Negotiation of bills. 31. Negotiation of bill. 1. A bill is negotiated when it is transferred from one person to another in such a manner as to constitute the transferee the holder of the bill. 2. A bill payable to bearer is negotiated by delivery. 3. A bill payable to order is negotiated by the endorsement of the holder completed by delivery. 4. Where the holder of a bill payable to his order transfers it for value without endorsing it, the transfer gives the transferee such title as the transferor had in the bill, and the transferee in addition acquires the right to have the endorsement of the transferor. 5. Where any person is under obligation to endorse a bill in a representative capacity, he may endorse the bill in such terms as to negative personal liability. 32. Requisites of a valid endorsement. An endorsement, in order to operate as a negotiation, must comply with the following conditions, namely, 1. It must be written on the bill itself and be signed by the endorser. The simple signature of the endorser on the bill, without additional words, is sufficient. An endorsement written on an allonge or on a copy of a bill issued or negotiated in a country where copies are recognized is deemed to be written on the bill itself. 2. It must be an endorsement of the entire bill, a partial endorsement, that is to say, an endorsement which purports to transfer to the endorsee a part only of the amount payable, or which purports to transfer the bill to 2 or more endorsees severally, does not operate as a negotiation of the bill. 3. Where a bill is payable to the order of 2 or more payees or endorsees who are not partners, all must endorse, unless the one endorsing has authority to endorse for the others. 4. Where, in a bill payable to order, the payee or endorsee is wrongly designated or his name is misspelt, he may endorse the bill as therein described, adding, if he thinks fit, his proper signature. 5. Where there are 2 or more endorsements on a bill, each endorsement is deemed to have been made in the order in which it appears on the bill, until the contrary is proved. 6. An endorsement may be made in blank or special. It may also contain terms making it restrictive. 33. Conditional endorsement. Where a bill purports to be endorsed conditionally, the condition may be disregarded by the payer, and payment to the endorsee is valid whether the condition has been fulfilled or not. 34. Endorsement in blank and special endorsement. 1. An endorsement in blank specifies no endorsee, and a bill so endorsed becomes payable to bearer. 2. A special endorsement specifies the person to whom or to whose order the bill is to be payable. 3. The provisions of this act relating to a payee apply with the necessary modifications to an endorsee under a special endorsement. 4. When a bill has been endorsed in blank, any holder may convert the blank endorsement into a special endorsement by writing above the endorser's signature a direction to pay the bill to or to the order of himself or some other person. 35. Restrictive endorsement. 1. An endorsement is restrictive which prohibits the further negotiation of the bill or which expresses that it is a mere authority to deal with the bill as thereby directed and not a transfer of the ownership thereof, as for example if a bill be endorsed pay D only, or pay D for the account of X, or pay D, or order for collection. 2. A restrictive endorsement gives the endorsee the right to receive payment of the bill and to sue any party thereto that his endorser could have sued, but gives him no power to transfer his rights as endorsee unless it expressly authorize him to do so. 3. Where a restrictive endorsement authorizes further transfer, all subsequent endorsees take the bill with the same rights and subject to the same liabilities as the first endorsee under the restrictive endorsement. 36. Negotiation of overdue or dishonored bill. 1. Where a bill is negotiable in its origin and continues to be negotiable until it has been A. restrictively endorsed or B. discharged by payment or otherwise. 2. Where an overdue bill is negotiated, it can only be negotiated subject to any defect of title affecting it at its maturity, and thenceforward no person who takes it can acquire or give a better title than that which the person from whom he took it had. 3. A bill payable on demand is deemed to be overdue within the meaning and for the purposes of this section, when it appears on the face of it to have been in circulation for an unreasonable length of time. What is an unreasonable length of time for this purpose is a question of fact. 4. Except where an endorsement bears date after the maturity of the bill. Every negotiation is prima facie deemed to have been effected before the bill was overdue. 5. Where a bill which is not overdue has been dishonored, any person who takes it with notice of the dishonor takes it subject to any defect of title attaching thereto at the time of dishonor. But nothing in this subsection shall affect the rights of a holder in due course. 37. Negotiation of bill to party already liable thereon. Where a bill is negotiated back to the drawer or to a prior endorser or to the acceptor, such party may, subject to the provisions of this act, reissue and further negotiate the bill, but he's not entitled to enforce payment of the bill against any intervening party to whom he was previously liable. 38. Rights of the holder. The rights and powers of the holder of a bill are as follows. 1. He may sue on the bill in his own name. 2. Where he is a holder in due course, he holds the bill free from any defect of title of prior parties, as well as from mere personal defenses available to prior parties among themselves, and may enforce payment against all parties liable on the bill. 3. Where his title is defective A. If he negotiates the bill to a holder in due course, that holder obtains a good and complete title to the bill. And B. If he obtains payment of the bill, a person who pays him in due course gets a valid discharge for the bill. General duties of the holder. 39. When presentment for acceptance is necessary. 1. Where a bill is payable after sight, presentment for acceptance is necessary in order to fix the maturity of the instrument. 2. Where a bill expressly stipulates that it shall be presented for acceptance, or where a bill is drawn payable elsewhere than at the residence or place of business of the drawee, it must be presented for acceptance before it can be presented for payment. 3. In no other case is presentment for acceptance necessary in order to render liable any party to the bill. 4. Where the holder of a bill, drawn payable elsewhere than at the place of business or residence of the drawee, has not time, with the exercise of reasonable diligence, to present the bill for acceptance before presenting it for payment on the day that it falls due, the delay caused by presenting the bill for acceptance before presenting it for payment is excused, and does not discharge the drawer and endorsers. 40 time for presenting bill payable after sight. 1. Subject to the provisions of this act, when a bill payable after sight is negotiated, the holder must either present it for acceptance or negotiate it within a reasonable time. 2. If he do not do so, the drawer and all endorsers prior to that holder are discharged. In determining what is a reasonable time within the meaning of this section, regard shall be had to the nature of the bill, the usage of trade with respect to similar bills, and the facts of the particular case. 41 rules as to presentment for acceptance and excuses for non-presentment. 1. A bill is duly presented for acceptance, which is presented in accordance with the following rules. A. The presentment must be made by or on behalf of the holder to the drawee or to some person authorized to accept or refuse acceptance on his behalf at a reasonable hour on a business day and before the bill is overdue. B. Where a bill is addressed to 2 or more drawees who are not partners, presentment must be made to them all, unless one has authority to accept for all. Then presentment may be made to him only. C. Where the drawee is dead, presentment may be made to his personal representative. D. Where the drawee is bankrupt, presentment may be made to him or to his trustee. E. Where authorized by agreement or usage, a presentment through FA postal operator is sufficient. 2. Presentment in accordance with these rules is excused, and a bill may be treated as dishonored by non-acceptance. A. Where the drawee is dead or bankrupt, or is a fictitious person or a person not having capacity to contract by bill. B. Where, after the exercise of reasonable diligence, such presentment cannot be effected. C. Where, although the presentment has been irregular, acceptance has been refused on some other ground. 3. The fact that the holder has reason to believe that the bill, on presentment, will be dishonored does not excuse presentment. Textual Amendments F. 5 words in S41-1, March 26, 2001, by SI 2001 1149 Art. 3-1 Sh. 1 para. 4-3. 42 Non-acceptance. When a bill is duly presented for acceptance and is not accepted within the customary time, the person presenting it must treat it as dishonored by non-acceptance. If he do not, the holder shall lose his right of recourse against the drawer and endorsers. 43. Dishonor by non-acceptance and its consequences. 1. A bill is dishonored by non-acceptance. A. When it is duly presented for acceptance, and such an acceptance as is prescribed by this act is refused or cannot be obtained, or B. 2. Subject to the provisions of this act, when a bill is dishonored by non-acceptance, an immediate right of recourse against the drawer and endorsers accrues to the holder, and no presentment for payment is necessary. When presentment for acceptance is excused and the bill is not accepted. 44 duties as to qualified acceptances. 1. The holder of a bill may refuse to take a qualified acceptance, and if he does not obtain an unqualified acceptance, may treat the bill as dishonored by non-acceptance. 2. Where a qualified acceptance is taken, and the drawer or an endorser has not expressly or impliedly authorized the holder to take a qualified acceptance, or does not subsequently assent thereto, such drawer or endorser is discharged from his liability on the bill. The provisions of this subsection do not apply to a partial acceptance whereof due notice has been given. Where a foreign bill has been accepted as to part, it must be protested as to the balance. 3. When the drawer or endorser of a bill receives notice of a qualified acceptance and does not within a reasonable time express his dissent to the holder, he shall be deemed to have assented thereto. 45 rules as to presentment for payment. Subject to the provisions of this act, a bill must be duly presented for payment. If it be not so presented, the drawer and endorsers shall be discharged. A bill is duly presented for payment, which is presented in accordance with the following rules. 1. Where the bill is not payable on demand, presentment must be made on the day it falls due. 2. Where the bill is payable on demand, then, subject to the provisions of this act, presentment must be made within a reasonable time after its issue in order to render the drawer liable, and within a reasonable time after its endorsement in order to render the endorser liable. In determining what is a reasonable time, regard shall be had to the nature of the bill, the usage of trade with regard to similar bills, and the facts of the particular case. 3. Presentment must be made by the holder, or by some person authorized to receive payment on his behalf, at a reasonable hour on a business day, at the proper place, as hereinafter defined. either to the person designated by the bill as payer or to some person authorized to pay or refuse payment on his behalf if with the exercise of reasonable diligence such person can there be found. 4. A bill is presented at the proper place. A. Where a place of payment is specified in the bill and the bill is there presented. B. Where no place of payment is specified, but the address of the drawee or acceptor is given in the bill and the bill is there presented. C. Where no place of payment is specified and no address given, and the bill is presented at the drawee's or acceptor's place of business if known, and if not, at his ordinary residence if known. D. If any other case, if presented to the drawee or acceptor wherever he can be found, or if presented at his last known place of business or residence. 5. Where a bill is presented at the proper place, and after the exercise of reasonable diligence no person authorized to pay or refuse payment can be found there, no further presentment to the drawee or acceptor is required. 6. Where a bill is drawn upon or accepted by 2 or more persons who are not partners and no place of payment is specified, presentment must be made to them all. 7. Where the drawee or acceptor of a bill is dead and no place of payment is specified, presentment must be made to a personal representative, if such there be, and with the exercise of reasonable diligence he can be found. 8. Where authorized by agreement or usage of presentment through FA postal operator is sufficient. Textual amendments. F6 words in S45-8 substituted March 26, 2001 by SI 2001 1149 art 3-1 sh 1 para 4-4. 46 excuses for delay or non-presentment for payment. 1. Delay in making presentment for payment is excused when the delay is caused by circumstances beyond the control of the holder and not imputable to his default misconduct or negligence. When the cause of delay ceases to operate, presentment must be made with reasonable diligence. 2. Presentment for payment is dispensed with. Where, after the exercise of reasonable diligence, presentment, as required by this Act, cannot be effected. The fact that the holder has reason to believe that the bill will, on presentment, be dishonored, does not dispense with the necessity for presentment. B. Where the drawee is a fictitious person. C. As regards the drawer, where the drawee or acceptor is not bound as between himself and the drawer to accept or pay the bill, and the drawer has no reason to believe that the bill would be paid if presented. D. As regards an endorser, where the bill was accepted or made for the accommodation of that endorser, and he has no reason to expect that the bill would be paid if presented. E. By waiver of presentment, express or implied. 47. Dishonored by non-payment. 1. A bill is dishonored by non-payment A. when it is duly presented for payment and payment is refused or cannot be obtained. Or B. When presentment is excused and the bill is overdue and unpaid. 2. Subject to the provisions of this Act, when a bill is dishonored by non-payment, an immediate right of recourse against the drawer and endorsers accrues to the holder. 48. Notice of dishonor and effect of non-notice. Subject to the provisions of this Act, when a bill has been dishonored by non-acceptance or by non-payment, notice of dishonor must be given to the drawer and each endorser, and any drawer or endorser to whom such notice is not given is discharged, provided that 1. Where a bill is dishonored by non-acceptance and notice of dishonor is not given, the rights of a holder in due course subsequent to the omission shall not be prejudiced by the omission. 2. Where a bill is dishonored by non-acceptance and due notice of dishonor is given, it shall not be necessary to give notice of a subsequent dishonor by non-payment unless the bill shall in the meantime have been accepted. 49 rules as to notice of dishonor. Notice of dishonor, in order to be valid and effectual, must be given in accordance with the following rules. 1. The notice must be given by or on behalf of the holder, or by or on behalf of an endorser who, at the time of giving it, is himself liable on the bill. 2. Notice of dishonor may be given by an agent either in his own name or in the name of any party entitled to give notice, whether that party be his principal or not. 3. Where the notice is given by or on behalf of the holder, it inures for the benefit of all subsequent holders and all prior endorsers who have a right of recourse against the party to whom it is given. 4. Where notice is given by or on behalf of an endorser entitled to give notice as hereinbefore provided, it inures for the benefit of the holder and all endorsers subsequent to the party to whom notice is given. 5. The notice may be given in writing or by personal communication, and may be given in any terms which sufficiently identify the bill and intimate that the bill has been dishonored by non-acceptance or non-payment. 6. The return of a dishonored bill to the drawer or an endorser is, in point of form, deemed a sufficient notice of dishonor. 7. A written notice need not be signed, and an insufficient written notice may be supplemented and validated by verbal communication. A misdescription of the bill shall not vitiate the notice unless the party to whom the notice is given is in fact misled thereby. 8. Where notice of dishonor is required to be given to any person, it may be given either to the party himself or to his agent in that behalf. 9. Where the drawer or endorser is dead and the party giving notice knows it, the notice must be given to a personal representative if such there be, and with the exercise of reasonable diligence he can be found. 10. Where the drawer or endorser is bankrupt, notice may be given either to the party himself or to the trustee. 11. Where there are 2 or more drawers or endorsers who are not partners, notice must be given to each of them, unless one of them has authority to receive such notice for the others. 12. The notice may be given as soon as the bill is dishonored, and must be given within a reasonable time thereafter. In the absence of special circumstances, notice is not deemed to have been given within a reasonable time, unless A. Where the person giving and the person to receive notice reside in the same place, the notice is given or sent off in time to reach the latter on the day after the dishonor of the bill. B. Where the person giving and the person to receive notice reside in different places, the notice is sent off on the day after the dishonor of the bill if there be a post at a convenient hour on that day. And if there be no such post on that day, then by the next post thereafter. 13. Where a bill, when dishonored, is in the hands of an agent, he may either himself give notice to the parties liable on the bill, or he may give notice to his principal. If he give notice to his principal, he must do so within the same time as if he were the holder, and the principal upon receipt of such notice has himself the same time for giving notice as if the agent had been an independent holder. 14. Where a party to a bill receives due notice of dishonor, he has after the receipt of such notice the same period of time for giving notice to antecedent parties that the holder has after the dishonor. Where a notice of dishonor is duly addressed and posted, the sender is deemed to have given due notice of dishonor, notwithstanding any miscarriage by the F7 postal operator concerned. Actual amendments. F. 7 words in S. 4915, substituted March 26, 2001, by SI 2001 1149 Art 31 1 para 45 50 excuses for non-notice and delay. 1. Delay in giving notice of dishonor is excused where the delay is caused by circumstances beyond the control of the party giving notice and not imputable to his default, misconduct, or negligence. When the cause of delay ceases to operate, the notice must be given with reasonable diligence. 2. Notice of dishonor is dispensed with. A. When, after the exercise of reasonable diligence, notice as required by this act cannot be given to or has not reached the drawer or endorser sought to be charged. B. By waiver express or implied. Notice of dishonor may be waived before the time of giving notice has arrived, or after the omission to give due notice. As regards the drawer in the following cases, namely, 1. Where drawer and drawee are the same person. 2. Where the drawee is a fictitious person or A. Not having capacity to contract. 3. Where the drawer is the person to whom the bill is presented for payment. 4. Where the drawee or acceptor is, as between himself and the drawer, under no obligation to accept or pay the bill. 5. Where the drawer has countermanded payment. As regards the endorser in the following cases, namely, 1. Where the drawee is a fictitious person or a person not having capacity to contract, and the endorser was aware of the fact at the time he endorsed the bill. 2. Where the endorser is the person to whom the bill is presented for payment. 3. Where the bill was accepted or made for his accommodation. 51. Noting or protest of bill. 1. Where an inland bill has been dishonored, it may, if the holder think fit, be noted for non-acceptance or non-payment, as the case may be, but it shall not be necessary to note or protest any such bill in order to preserve the recourse against the drawer or endorser. 2. Where a foreign bill, appearing on the face of it to be such, has been dishonored by non-acceptance, it must be duly protested for non-acceptance, and where such a bill, which has not been previously dishonored by non-acceptance, is dishonored by non-payment, it must be duly protested for non-payment. If it be not so protested, the drawer and endorsers are discharged. Where a bill does not appear on the face of it to be a foreign bill, protest thereof in case of dishonor is unnecessary. 3. A bill which has been protested for non-acceptance may be subsequently protested for non-payment. 4. Subject to the provisions of this act, when a bill is noted or protested, fate it may be noted on the day of its dishonor, and must be noted not later than the next succeeding business day. When a bill has been duly noted, the protest may be subsequently extended as of the date of the noting. 5. Where the acceptor of a bill becomes bankrupt or insolvent or suspends payment before it matures, the holder may cause the bill to be protested for better security against the drawer and endorsers. 6. A bill must be protested at the place where it is dishonored, provided that A. When a bill is presented through F9, a postal operator, and returned by post dishonored, it may be protested at the place to which it is returned, and on the day of its return, if received during business hours, and if not received during business hours, then not later than the next business day. B. When a bill drawn payable at the place of business or residence of some person other than the drawee has been dishonored by non-acceptance, it must be protested for non-payment at the place where it is expressed to be payable, and no further presentment for payment to or demand on the drawee is necessary. 7. A protest must contain a copy of the bill, and must be signed by the notary making it, and must specify A. The person at whose request the bill is protested, B. The place and date of protest, the cause or reason for protesting the bill, the demand made, and the answer given, if any, or the fact that the drawee or acceptor could not be found. Person. F107A in subsection 7, notary, includes a person who, for the purposes of the Legal Services Act 2007, is an authorized person in relation to any activity which constitutes a notarial activity within the meaning of that act. 8. Where a bill is lost or destroyed, or is wrongly detained from the person entitled to hold it, protest may be made on a copy or written particulars thereof. 9. Protest is dispensed with by any circumstance which would dispense with notice of dishonor. Delay in noting or protesting is excused when the delay is caused by circumstances beyond the control of the holder, and not imputable to his default misconduct or negligence. When the cause of delay ceases to operate, the bill must be noted or protested with reasonable diligence. Textual amendments. 8 words substituted by bills of exchange, time of noting. Act 1917 C 48 S1. F 9 words in S 51-6. A. Substituted March 26, 2001 by SI 2001 1149th. Art. 3-1 sh 1 para. 4-6 F 10 S 51-7A, inserted January 1st, 2010 by Legal Services Act 2007, by Legal Services Act 21 para 9, with SS 29, 192, 193, SI 2009 with SS 2 ch. 52 duties of holder as regards drawee or acceptor. 1. When a bill is accepted, generally presentment for payment is not necessary in order to render the acceptor liable. 2. When by the terms of a qualified acceptance presentment for payment is required, the acceptor, in the absence of an express stipulation to that effect, is not discharged by the omission to present the bill for payment on the day that it matures. 3. In order to render the acceptor of a bill liable, it is not necessary to protest it, or that notice of dishonor should be given to him. 4. 11. Subject to Part 4. A presentment by electronic means. Where the holder of a bill presents it for payment, he shall exhibit the bill to the person from whom he demands payment, and when a bill is paid, the holder shall forthwith deliver it up to the party paying it. Textual amendments. F 11 words in S 52-4, inserted 26.3, inserted in 15, 31.7.2016, insofar as not already in force by Small Business, Enterprise and Employment Act 2015 C 26 SS 13.3, 164.4, liabilities offertees. 53 funds in hands of drawee. 1. A bill of itself does not operate as an assignment of funds in the hands of the drawee available for the payment thereof. And the drawee of a bill who does not accept as required by this act is not liable on the instrument. This subsection shall not extend to Scotland. 2. F1213, subject to Section 75A of this Act, and Scotland, where the drawee of a bill F14 other than a check has in his hands funds available for the payment thereof. The bill operates as an assignment of the sum for which it is drawn in favor of the holder from the time the bill is presented to the drawee. F12 words in S53.2 cease to have effect December 4th, 2009 by Banking Act 2009 C1 SS 254.4 I 263.2 with S 247 F13 words inserted S. By Law Reform Miscellaneous Provisions Scotland Act 1985 C73 CIF 30 S 11 14 words in S53(2). Inserted December 4th, 2009 by Banking Act 2009, C 254 Atha 263 200 leave acceptor. The acceptor of a bill, 1. Engages that he will pay it according to the tenor of his acceptance. 2. Is precluded from denying to a holder in due course. A. The existence of the drawer, the genuineness of his signature, and his capacity and authority to draw the bill. B. In the case of a bill payable to drawer's order, the then capacity of the drawer to endorse, but not the genuineness or validity of his endorsement. C. In the case of a bill payable to the order of a third person, the existence of the payee and his then capacity to endorse, but not the genuineness or validity of his endorsement. 55. Liability of drawer or endorser. 1. The drawer of a bill by drawing it. A. Engages that on due presentment it shall be accepted and paid according to its tenor, and that if it be dishonored, he will compensate the holder or any endorser who is compelled to pay it. Provided that the requisite proceedings on dishonor be duly taken, B is precluded from denying to a holder in due course the existence of the payee and his then capacity to endorse. 2. The endorser of a bill by endorsing it. A. Engages that on due presentment it shall be accepted and paid according to its tenor, and that if it be dishonored, he will compensate the holder or a subsequent endorser who is compelled to pay it. Provided that the requisite proceedings on dishonor be duly taken, B is precluded from denying to a holder in due course the genuineness and regularity in all respects of the drawer's signature and all previous endorsements. C is precluded from denying to his immediate or subsequent endorsee that the bill was at the time of his endorsement a valid and subsisting bill, and that he had then a good title thereto. 56. Stranger signing bill liable as endorser. Where a person signs a bill otherwise than as drawer or acceptor, he thereby incurs the liabilities of an endorser to a holder in due course. 57. Measure of damages against parties to dishonored bill. Where a bill is dishonored, the measure of damages, which shall be deemed to be liquidated damages, shall be as follows. 1. The holder may recover from any party liable on the bill, and the drawer who has been compelled to pay the bill may recover from the acceptor. And an endorser who has been compelled to acceptor or from the drawer, or from a prior endorser. A. The amount of the bill. B. Interest thereon from the time of presentment for payment, if the bill is payable on demand. And from the maturity of the bill in any other case. C. The expenses of noting, or, when protest is necessary and the protest has been extended, the expenses of protest. 2. F15. 3. Whereby this act interest may be recovered as damages, such interest may, if justice require it, be withheld wholly or in part, and where a bill is expressed to be payable with interest at a given rate. Interest as damages may or may not be given at the same rate as interest proper. Textual amendments, F15 SS 57-2, 72-4, repealed by Administration of Justice, Act 1977, C38, S42 F3, with saving for bills drawn before August 29, 1977. 58. Transfer by delivery and transferee. 1. Where the holder of a bill payable to bearer negotiates it by delivery without endorsing it, he is called a transferor by delivery. 2. A transfer by delivery is not liable on the instrument. 3. A transfer by delivery who negotiates a bill thereby warrants to his immediate transferee, being a holder for value, that the bill is what it purports to be, that he has a right to transfer it, and that at the time of transfer he is not aware of any fact which renders it valueless. Discharge of bill. 59. Payment in due course. 1. A bill is discharged by payment in due course by or on behalf of the drawee or acceptor. Payment in due course means payment made at or after the maturity of the bill to the holder thereof in good faith and without notice that his title to the bill is defective. 2. Subject to the provisions herein after contained, when a bill is paid by the drawer or an endorser, it is not discharged, but A. Where a bill payable to or to the order of a third party is paid by the drawer may enforce payment thereof against the acceptor, but may not reissue the bill. B, where a bill is paid by an endorser, or where a bill payable to drawer's order is paid by the drawer. The party paying it is remitted to his former rights as regards the acceptor or antecedent parties, and he may, if he thinks fit, strike out his own subsequent endorsements and again negotiate the bill. 3. Where an accommodation bill is paid in due course by the party accommodated, the bill is discharged. 60. Banker paying demand draft whereon endorsement is forged. When a bill payable to order on demand is drawn on a banker, and the banker on whom it is drawn pays the bill in good faith and in the ordinary course of business, it is not incumbent on the banker to show that the endorsement of the payee or any subsequent endorsement was made by or under the authority of the person whose endorsement it purports to be, and the banker is deemed to have paid the bill in due course, although such endorsement has been forged or made without authority. 61. Acceptor the holder at maturity. When the acceptor of a bill is or becomes the holder of it at or after its maturity, in his own right, the bill is discharged. 62. Express waiver. 1. When the holder of a bill at or after its maturity absolutely and unconditionally renounces his rights against the acceptor, the bill is discharged. The renunciation must be in writing, unless the bill is delivered up to the acceptor. 2. The liabilities of any party to a bill may in like manner be renounced by the holder before, at, or after its maturity, but nothing in this section shall affect the rights of a holder in due course without notice of the renunciation. 63. Cancellation. 1. Where a bill is intentionally canceled by the holder or his agent, and the cancellation is apparent thereon, the bill is discharged. 2. In like manner, any party liable on a bill may be discharged by the intentional cancellation of his signature by the holder or his agent. In such case, any endorser who would have had a right of recourse against the party whose signature is canceled is also discharged. 3. A cancellation made unintentionally, or under a mistake, or without the authority of the holder, is inoperative. But where a bill or any signature thereon appears to have been canceled, the burden of proof lies on the party who alleges that the cancellation was made unintentionally, or under a mistake, or without authority. 64. Alteration of bill. 1. Where a bill or acceptance is materially altered without the assent of all parties liable on the bill is avoided except as against a party who has himself made, authorized, or assented to the alteration, and subsequent endorsers. Provided that, where a bill has been materially altered, but the alteration is not apparent, and the bill is in the hands of a holder in due course, such holder may avail himself of the bill as if it had not been altered, and may enforce payment of it according to its original tenor. 2. In particular, the following alterations are material, namely, any alteration of the date, the sum payable, the time of payment, the place of payment, and where a bill has been accepted generally. The addition of a place of payment without the acceptor's assent. Modifications, etc., not altering text. See cess. 64. Excluded by Decimal Currency Act 1969, C19, S32. Acceptance and payment for honor. 65. Acceptance for honor super protest. 1. Where a bill of exchange has been protested for dishonor by non-acceptance or protested for better security and is not overdue, any person, not being a party already liable thereon, may, with the consent of the holder, intervene and accept the bill super protest for the honor of any party liable thereon, or for the honor of the person for whose account the bill is drawn. 2. A bill may be accepted for honor for part only of the sum for which it is drawn. 3. An acceptance for honor super protest in order to be valid must A. Be written on the bill and indicate that it is an acceptance for honor. B. Be signed by the acceptor for honor. 4. Where an acceptance for honor does not expressly state for whose honor it is made, it is deemed to be an acceptance for the honor of the drawer. 5. Where a bill payable after sight is accepted for honor, its maturity is calculated from the date of the noting for non-acceptance and not from the date of the acceptance for honor. 66. Liability of acceptor for honor. 1. The acceptor for honor of a bill by accepting it engages that he will, on due presentment, pay the bill according to the tenor of his acceptance if it is not paid by the drawee, provided it has been duly presented for payment and protested for non-payment, and that he receives notice of these facts. 2. The acceptor for honor is liable to the holder and to all parties to the bill subsequent to the party for whose honor he is accepted. 67. Presentment to acceptor for honor. 1. Where a dishonored bill has been accepted for honor super protest, or contains a reference in case of need, it must be protested for non-payment before it is presented for payment to the acceptor for honor, or referee, in case of need. 2. Where the address of the acceptor for honor is in the same place where the bill is protested for non-payment, The bill must be presented to him not later than the day following its maturity, and where the address of the acceptor for honor is in some place other than the place where it was protested for non-payment, the bill must be forwarded not later than the day following its maturity for presentment to him. 3. Delay in presentment or non-presentment is excused by any circumstance which would excuse delay in presentment for payment or non-presentment for payment. 4. When a bill of exchange is dishonored by the acceptor for honor, it must be protested for non-payment by him. 68 Payment for honor super protest. 1. Where a bill has been protested for non-payment, any person may intervene and pay its super protest for the honor of any party liable thereon, or for the honor of the person for whose account the bill is drawn. 2. Where two or more persons offer to pay a bill for the honor of different parties, the person whose payment will discharge most parties to the bill shall have the preference. 3. Payment for honor super protest, in order to operate as such and not as a mere voluntary payment, must be attested by a notarial act of honor which may be appended to the protest or form an extension of it. 4. The notarial act of honor must be founded on a declaration made by the payer for honor, or his agent in that behalf, declaring his intention to pay the bill for honor and for whose honor he pays. 5. Where a bill has been paid for honor, all parties subsequent to the party for whose honor is paid are discharged, but the payer for honor is subrogated for and succeeds to both the rights and duties of the holder as regards the party for whose honor he pays, and all parties liable to that party. 6. The payer for honor, on paying to the holder the amount of the bill and the notarial expenses incidental to its dishonor, is entitled to receive both the bill itself and the protest. If the holder do not on demand deliver them up, he shall be liable to the payer for honor in damages. 7. Where the holder of a bill refuses to receive payment super protest, he shall lose his right of recourse against any party who would have been discharged by such payment. Lost instruments. 69 Holders' right to duplicate of lost bill. Where a bill has been lost before it is overdue, the person who is the holder of it may apply to the drawer to give him another bill of the same tenor. Giving security to F1670. Drawer, if required to indemnify him against all persons whatever, in case the bill alleged to have been lost shall be found again. If the drawer on request as aforesaid refuses to give such duplicate bill, he may be compelled to do so. Action on lost bill. In any action or proceeding upon a bill, the court or a judge may order that the loss of the instrument shall not be set up, provided an indemnity be given to the satisfaction of the court or judge against the claims of any other person upon the instrument in question. Textual amendments. F16S 70, repealed NI by Judicature Northern Ireland, Act 1978 C 23 CIF 38 S 122-3, Bill in a set. 71 Rules as to sets. 1. Where a bill is drawn in a set, each part of the set being numbered, and containing a reference to the other parts, the whole of the parts constitute one bill. 2. Where the holder of a set endorses two or more parts to different persons, he is liable on every such part, and every endorser subsequent to him is liable on the part he has himself endorsed, as if the said parts were separate bills. 3. Where two or more parts of a set are negotiated to different holders in due course, the holder whose title first accrues is as between such holders deemed the true owner of the bill. But nothing in this subsection shall affect the rights of a person who in due course accepts or pays the part first presented to him. 4. The acceptance may be written on any part, and it must be written on one part only. If the drawee accepts more than one part, and such accepted parts get into the hands of different holders in due course, he is liable on every such part as if it were a separate bill. 5. When the acceptor of a bill drawn in a set pays it without requiring the part bearing his acceptance to be delivered up to him, and that part at maturity is outstanding in the hands of a holder in due course, he is liable to the holder thereof. 6. Subject to the preceding rules, where any one part of a bill drawn in a set is discharged. By payment or otherwise, the whole bill is discharged. Conflict of laws. 72 Rules where laws conflict. Where a bill drawn in one country is negotiated, accepted, or payable in another, the rights, duties, and liabilities of the parties thereto are determined as follows. 1. The validity of a bill as regards requisites in form is determined by the law of the place of issue, and the validity as regards requisites in form of the supervening contracts, such as acceptance or endorsement, or acceptance super protest, is determined by the law of the place where such contract was made. Provided that A. Where a bill is issued out of the United Kingdom, it is not invalid by reason only that it is not stamped in accordance with the law of the place of issue. B, where a bill issued out of the United Kingdom conforms, as regards requisites in form, to the law of the United Kingdom it may, for the purpose of enforcing payment thereof, be treated as valid as between all persons who negotiate, hold, or become parties to it in the United Kingdom. 2. Subject to the provisions of this Act, the interpretation of the drawing, endorsement, acceptance, or acceptance supra protest of a bill is determined by the law of the place where such contract is made. Provided that, where an inland bill is endorsed in a foreign country, the endorsement shall, as regards the payer, be interpreted according to the law of the United Kingdom. 3. The duties of the holder with respect to presentment for acceptance or payment, and the necessity for or sufficiency of a protest, or notice of dishonor, or otherwise, are determined by the law of the place where the act is done or the bill is dishonored. 4. F17. 5. Where a bill is drawn in one country and is payable in another, the due date thereof is determined according to the law of the place where it is payable. Textual amendments F17 SS 57.2, 72.4, repealed by Administration of Justice Act 1977 C 38 S 42 a 3, with saving for bills drawn before August 29, 1977. Part 3, checks on a banker. 73 check defined. A check is a bill of exchange drawn on a banker, payable on demand. Except, as otherwise provided in this part, the provisions of this act applicable to a bill of exchange payable on demand apply to a check. Modifications, etc., not altering text C 7S 73, extended by Finance Act 1 Finance Act 139 C 41 S 35-2 SI 1957 2228, 1957 IP 801, and National Loans Act 1968 C 13 S 14-7. 74 presentment of check for payment, subject to the provisions of this act. 1. Where a check is not presented for payment within a reasonable time of its issue, and the drawer, or the person on whose account it is drawn, had the right at the time of such presentment as between him and the banker to have the check paid and suffers actual damage through the delay. He is discharged to the extent of such damage, that is to say, to the extent to which such drawer or person is a creditor of such banker to a larger amount than he would have been had such check been paid. 2. In determining what is a reasonable time, regard shall be had to the nature of the instrument, the usage of trade and of bankers, and the facts of the particular case. 3. The holder of such check as to which such drawer or person is discharged shall be a creditor, in lieu of such drawer or person, of such banker to the extent of such discharge, and entitled to recover the amount from him. F18 F 1874, a presentment of check for payment, alternative place of presentment, where the banker on whom a check is drawn, A, has by notice published in the London, Edinburgh, and Belfast Gazettes specified an address at which checks drawn on him may be presented, and B has not by notice so published cancelled the specification of that address. The check is also presented at the proper place if it is presented there. Textual amendments FF18s. 74 inserted 28.1196 by SI 1996 2993 Zart. 3. F1974B, presentment of check for payment, alternative means of presentment by banker. Textual amendments F19 SS. 74 billions. 74 Celsius is omitted March 26, 2015, July 30, 1st, 2016, insofar as not already in force by virtue of Small Business, Enterprise, and Employment Act and 2015 C26 SS. 13.4, 164.4. F. 1974 Celsius's checks presented for payment under Section 74 billions, disapplication of. Section 52.4. Textual amendments F19 SS. 74 billions. 74 Celsius is omitted March 26, 2015, July 31st, 2016, insofar as not already in force by virtue of Small Business, Enterprise, and Employment Act 2015, 26 SS. 13.4, 164.4. 75 Revocation of banker's authority. The duty and authority of a banker to pay a check drawn on him by his customer are determined by 1. Countermand of payment. 2. Notice of the customer's death. F2075A. F21.1. On the countermand of payment of a check, the banker shall be treated as having no funds available for the payment of the check. 2. This section applies to Scotland only. Textual Amendments FF20s, 75, inserted S. By Law Reform Miscellaneous Provisions, Scotland Act 1985 C73 S if 30, S11B, F21, S 75, as ceases to have effect December 4th, 2009, by virtue of Banking Act 2009 C1 SS. 254 4B, 263 2, with S 247, cross checks, 76 general and special crossings defined. 1. Where a check bears across its face an addition of A. The words and company or any abbreviation thereof between two parallel transverse lines, either with or without the words not negotiable. Or B. Two parallel transverse lines simply, either with or without the words not negotiable. That addition constitutes a crossing, and the check is crossed generally. 2. Where a check bears across its face an addition of the name of a banker, either with or without the words not negotiable. That addition constitutes a crossing, and the check is crossed specially into that banker. Modifications, etc. Not altering text. 8S 76, extended by Checks Act 1906, S at 27, Reg. 21527, Reg. 82 and 620 Reg. 222C 9S 76 extended by SI. 47 Reg. 72S 76 extended by SI. 110 Reg. 72S 76 applied by SI. 114 Reg. 761 applied with modifications June 4th, 2015 by the National Savings Regulations 2015 by the National Savered in 23rds, Regs 1158C 11S 761 applied June 4th, 2015 by the National Savings Number 2 Regulations 2015 is yet 11 National 1196 77 crossing by drawer or after issue. 1. A check may be crossed generally or specially by the drawer. 2. Where a check is uncrossed, the holder may cross it generally or specially. 3. Where a check is crossed generally, the holder may cross it specially. 4. Where a check is crossed generally or specially, the holder may add the words not negotiable. 5. Where a check is crossed specially, the banker to whom it is crossed may again cross it specially to another banker for collection. 6. Where an uncrossed check, or a check crossed generally, is sent to a banker for collection, he may cross it specially to himself. Modifications, etc., not altering text. C12S 77, extended by Checks Act 1957 C 36, CIF 14, S 5 and SI 1976. That check 22 C 13S 77, subsections 1, 3, 4, and 5, and, so far as it relates to cross checks, subsection 6 of section 77, extended by SI 1984, 779ths, Reg. 72, S, 77, subsections 1, 3, 4, and 5, and, so far as it relates to cross checks, subsection 6, extended by SI 1991, 1031sts, Reg. 72S 77, subsections 1, 3, 4, and 5, and so far as it relates to cross checks, subsection 6 applied by SI 1990 407th Reg. 72 C14S 77 1 5, and so far as it relates to cross checks, 6 extended by SI 1972, 641sts, 764, 765, 15S 77.6 applied with modifications June 4, 2015 by the National Savings Regulations 2015 Regs 1158cc S 77.6 applied June 4th, 2015 by the National Savings Number 2 Regulations 2015 applied 15 applied 1196 78 crossing a material part of check A crossing authorized by this act is a material part of the check. It shall not be lawful for any person to obliterate or, except as authorized by this act, to add to or alter the crossing. Modifications, etc., not altering text. C. 17S 78. Extended by Checks Act 1957 C 36 CIF 14 S5 SI 1972 641st. Reg 27 Reg 21527 Reg 82 and 620 Reg 222 C18 SS 7881 extended by SI 47 Reg 72 SS 78 to 81 extended by SI 110 Reg 72 SS 78 to 81 applied by SI 114 Reg 72C 19 SS 78 to 81 applied June 4th 2015 by the National Savings Number 2 Regulations 2015's Number 600 2001 96C 20 SS 78 to 81 applied with modifications June 4th 2015 by the National Savings Regulations 2015 June 4th 2000 affectations 1158 79 duties of banker as to cross checks. 1. Where a check is crossed specially to more than one banker, except when crossed to an agent for collection being a banker. The banker on whom it is drawn shall refuse payment thereof. 2. Where the banker on whom a check is drawn which is so crossed nevertheless pays the same, or pays a check crossed generally otherwise than to a banker, or if crossed specially otherwise than to the banker to whom it is crossed, or his agent for collection being a banker. He is liable to the true owner of the check for any loss he may sustain owing to the check having been so paid. Provided that, where a check is presented for payment which does not at the time of presentment appear to be crossed, or to have had a crossing which has been obliterated, or to have been added to or altered otherwise than is authorized by this act, the banker paying the check in good faith and without negligence shall not be responsible or incur any liability. Nor shall the payment be questioned by reason of the check having been crossed, or of the crossing having been obliterated or having been added to or altered otherwise than is authorized by this act, and of payment having been made otherwise than to a banker or to the banker to whom the check is or was crossed, or to his agent for collection being a banker, as the case may be. Modifications, etc., not altering text. Modifications of 415 by the National Savings No. 2 Regulations 2015 as I 2015 624th Regs 1196C 20 SS 78 to 81 applied with modifications June 4th 2015 by the National Savings Regulations 2015 June 4th 2000 affectations 1158C 21S 79 extended by Checks Act 1957C 36 CIF 14 S5 SI2 6 Reg 21527 Reg 82 and 620 Reg 22 C22 SS 7881 extended by SI 47 Reg 72 SS 78 to 81 extended by SI 110 Reg 72 SS 78 to 81 applied by SI 1991 1407 Reg 72 80 protection to banker and drawer where check is crossed. Where the banker, on whom a crossed check F22, including a check which under Section 81 or below or otherwise is not transferable, is drawn in good faith and without negligence pays it, if crossed generally, to a banker, and if crossed specially, to the banker to whom it is crossed, or his agent for collection being a banker, the banker paying the check, and if the check is come into the hands of the payee, the drawer, shall respectively be entitled to the same rights and be placed in the same position as if payment of the check had been made to the true owner thereof. Textual amendments. F22 words in S80, inserted June 16, 1992, by Checks Act 1992C 32 SS2 42, modifications, etc., not altering text. C19 SS 78 to 81, applied June 4th, 2015 by the National Savings No. 2 Regulations 2015. ASI 2015. 1. 96C 20 SS 78 to 81 applied with modifications June 4th, 2015, by the National Savings Regulations 2015, June 4th, 2000, petitions 1158, C23S, 80, extended by Checks Act 1957C, 36, Civ 14, S5, SI, Extex Reg 27, Reg 21527, Reg 82 and 620, Reg 22, C24SS 7881, extended by SI 47, Reg 72SS 78 to 81, extended by SI 110, Reg 72SS 78 to 81, applied by SI 1991 1407s, Reg 72 C25S80, applied July 31st, 2018, by the Electronic Presentment of Instruments, Evidence of Payment and Compensation for Losses Regulations 2018, applying 830 seconds, regs 1780, one effect of crossing on holder, where a person takes a cross check which bears on it the words not negotiable. He shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it had. Modifications, etc. Not altering text. Modifications of 4.2.4.15 by the National Savings, no. 2. Regulations, 2015. SI, 2015, 624ths, regs, 1196C, 20 SS, 78 to 81, applied with modifications, June 4th, 2015, by the National Savings Regulations, 2015, June 4th, 2000, petitions, 1158C, 26S, 81, extended by Checks Act 1957C, 36, Civ 14 S, 5 SI 26, Reg 727, Reg 21527, Reg 82 and 620, Reg 22, 2, C 27SS 7881, extended by SI 47, Reg 72SS 78 to 81, extended by SI 110, Reg 72SS 78 to 81, applied by SI 1991 1407, ASI 1, where a check is crossed and bears across its face the words account payee or a C payee, either with or without the word only, the check shall not be transferable, but shall only be valid as between the parties thereto. 2. A banker is not to be treated for the purposes of Section 80 above as having been negligent by reason only of his failure to concern himself with any purported endorsement of a check, which under subsection 1 above or otherwise is not transferable. Textual amendments F23S 81, inserted June 16, 1992, by Checks Act 1992, 32 SS 142 FF24. Textual amendments F24S 82, repealed by Checks Act 1957C, 36 Sh. 32 Bills of Exchange Act 1882C, 61 Part 4 Promissory Notes. Part 4 Promissory Notes 83. Promissory note defined. 1. A promissory note is an unconditional promise in writing made by one person to another, signed by the maker, engaging to pay, on demand or at a fixed or determinable future time, a sum certain in money, to, or to the order of, a specified person, or to bearer. 2. An instrument in the form of a note, payable to maker's order, is not a note within the meaning of this section unless and until it is endorsed by the maker. 3. A note is not invalid by reason only that it contains also a pledge of collateral security with authority to sell or dispose thereof. 4. A note which is, or on the face of it purports to be, both made and payable within the British Islands is an inland note. Any other note is a foreign note. 84. Delivery necessary. A promissory note is inchoate and incomplete until delivery thereof to the payee or bearer. 85. Joint and several notes. 1. A promissory note may be made by two or more makers, and they may be liable thereon jointly, or jointly and severally, according to its tenor. 2. Where a note runs, I promise to pay, and is signed by two or more persons, it is deemed to be their joint and several note. 86. Note, payable on demand. 1. Where a note payable on demand has been endorsed, it must be presented for payment within a reasonable time of the endorsement. If it be not so presented, the endorser is discharged. 2. In determining what is reasonable time, regard shall be had to the nature of the instrument, the usage of trade, and the facts of the particular case. 3. Where a note payable on demand is negotiated, it is not deemed to be overdue, for the purpose of affecting the holder with defects of title of which he had no notice, by reason that it appears that a reasonable time for presenting it for payment has elapsed since its issue. 87. Presentment of note for payment. 1. Where a promissory note is in the body of it made payable at a particular place, it must be presented for payment at that place in order to render the maker liable. In any other case, presentment for payment is not necessary in order to render the maker liable. 2. Presentment for payment is necessary in order to render the endorser of a note liable. 3. Where a note is in the body of it made payable at a particular place, presentment at that place is necessary in order to render an endorser liable. But when a place of payment is indicated by way of memorandum only, presentment at that place is sufficient to render the endorser liable, but a presentment to the maker elsewhere, if sufficient in other respects, shall also suffice. F. 25.4. This section is subject to Part 4, a presentment by electronic means textual amendments, F. 25S. 87.4, inserted 26, textual amendments, insofar as not already 1.7.2016, insofar as not already in force by Small Business, Enterprise and Employment Act 2015 C26 SS 13.5 164.4 88 liability of maker, the maker of a promissory note by making it. 1. Engages that he will pay it according to its tenor. 2. Is precluded from denying to a holder in due course the existence of the payee and his then capacity to endorse. 89 application of Part 2 notes. 1. Subject to the provisions in this part, and except as by this section provided, the provisions of this act relating to bills of exchange apply with the necessary modifications. To promissory notes. 2. In applying those provisions, the maker of a note shall be deemed to correspond to the acceptor of a bill, and the first endorser of a note shall be deemed to correspond with the drawer of an accepted bill payable to drawer's order. 3. The following provisions as to bills do not apply to notes, namely provisions relating to A. Presentment for acceptance, B. Acceptance, C. Acceptance super protest, D. Bills in a set. 4. Where a foreign note is dishonored, protest thereof is unnecessary. F26 Part 4A. Presentment of checks and other instruments by electronic means. Textual Amendments F26 PT. 4A inserted March 26, 2015, July 31st, 2016, insofar as not already in force by Small Business, Enterprise and Employment Act 2015 C26 SS 13.2 164.4 89A. 89 billions. Presentment of instruments by electronic means. 1. Presentment for payment of an instrument to which this section applies may be effected by provision of an electronic image of both faces of the instrument, instead of by presenting the physical instrument, if the person to whom presentment is made accepts the presentment as effective. This is subject to regulations under subsection 2 and to section 89 Celsius. 2. The Treasury may by regulations prescribe circumstances in which subsection 1 does not apply. 3. Regulations under subsection 2 may in particular prescribe circumstances by reference to A. Descriptions of instrument, B. Arrangements under which presentment is made, C. Descriptions of persons by or to whom presentment is made, D. Descriptions of persons receiving payment or on whose behalf payment is received. 4. Where presentment for payment is made under subsection 1, A. Any requirement, I. That the physical instrument must be exhibited, presented or delivered on or in connection with presentment or payment, including after presentment or payment, or in connection with dishonor for non-payment, or T. As to the day, time or place on or at which presentment of the physical instrument may be or is to be made, and B. Any other requirement which is inconsistent with subsection 1 does not apply. 5. Subsection 4 does not affect any requirement as to the latest time for presentment. References in subsections 4 and 5 to a requirement are to a requirement or prohibition, whether imposed by or under any enactment, by a rule of law, or by the instrument in question. 7. Where an instrument is presented for payment under this section, A. Any banker providing the electronic image, B. Any banker to whom it is provided, and C. Any banker making payment of the instrument as a result of provision of the electronic image, are subject to the same duties in relation to collection and payment of the instrument as if the physical instrument had been presented. This is subject to any provision made by or under this part. Instruments to which Section 89A applies. 1. subject to subsection 2, section 89A applies to A. A check, or B. Any other bill of exchange or any promissory note or other instrument. I. Which appears to be intended by the person creating it to enable a person to obtain payment from a banker indicated in it of the sum so mentioned. T. Payment, of which requires the instrument to be presented. And 2. Which, but for section 89A, could not be presented otherwise than by presenting the physical instrument. That does not apply to any banknote within the meaning given in Section 208 of the Banking Act 2009, F27, or to anything that is an electronic trade document for the purposes of the Electronic Trade Documents Act, 2023. See Section 2 of that Act. 3. The reference in subsection 1 to the person creating an instrument is A. In the case of a bill of exchange, a reference to the drawer. B. In the case of a promissory note, a reference to the maker. 4. For the purposes of subsection 1BI, an indication may be by code or number and need not indicate the payment is intended to be obtained from the banker. Textual amendments, F, 27 words in S 89 billions 2, inserted September 20th, 2023, by Electronic Trade Documents, Act 2023, C38, SS, 7182, 89 Celsius, 89D. Banker's obligation in relation to accepting physical instrument for presentment provision of an electronic image of an instrument does not constitute presentment of the instrument under Section 89A if the arrangements between A. The banker authorized to collect payment of the instrument on behalf of a customer, and B. That customer do not permit the customer to pay in the physical instrument, but instead require an electronic image to be provided whether to that banker or to any other person. Copies of instruments and evidence of payment. 1. The Treasury may by regulations make provision for A. Requiring a copy of an instrument paid as a result of presentment under Section 89A to be provided, on request, to the creator of the instrument by the banker who paid the instrument. B. A copy of an instrument provided in accordance with the regulations to be evidence of receipt by a person identified in accordance with the regulations of the sum payable by the instrument. 2. Regulations under subsection 1A may, in particular, A. Prescribe the manner and form in which a copy is to be provided. B. Require the copy to be certified to be a true copy of the electronic image provided to the banker making the payment on presentment under Section 89A. C. Provide for the copy to be accompanied by prescribed information. D. Require any copy to be provided free of charge or permit charges to be made for the provision of copies in prescribed circumstances. 3. The reference in subsection 1A to the creator of the instrument is A. In the case of a bill of exchange, a reference to the drawer. B. In the case of a promissory note, a reference to the maker. 89E compensation in cases of presentment by electronic means. 1. The Treasury may by regulations make provision for the responsible banker to compensate any person for any loss of a kind specified by the regulations which that person incurs in connection with electronic presentment or purported electronic presentment of an instrument. 2. In this section, electronic presentment or purported electronic presentment of an instrument includes A. Presentment of an instrument to which Section 89A applies under that section. B. Presentment of any other instrument by any means involving provision of an electronic image by which it may be presented for payment. C. Purported presentment for payment by any means involving provision of an electronic image of an instrument that may not be presented for payment in that way. D. Provision in purported presentment for payment of I. An electronic image that purports to be, but is not, an image of a physical instrument, including an image that has been altered electronically. Or T. An electronic image of an instrument which has no legal effect, or E. Provision in presentment or purported presentment for payment of an electronic image which has been stolen. 3. In this section, the responsible banker, in relation to electronic presentment or purported electronic presentment of an instrument, means A. The banker who is authorized to collect payment of the instrument on a customer's behalf, or B. If the holder of the instrument is a banker, that banker. 4. In this section, A. References to an instrument include references to an instrument which has no legal effect, whether because it has been fraudulently altered or created, or because it has been discharged. Or otherwise, B. In relation to an electronic image, which is not an image of physical instrument. References to the instrument are to a purported instrument of which it purports to be an image, and C. In relation to an instrument which is not a bill of exchange or promissory note. References to the holder are to the payee or endorsee of the instrument who is in possession of it, or, if it is payable to bearer, the person in possession of it. 5. Regulations under this section may in particular make provision for A. The responsible banker to be required to pay compensation irrespective of fault. B. Amount of compensation to be reduced by virtue of anything done, or any failure to act, by the person to whom compensation is payable. 6. Nothing in this section or regulations under it is to be taken to. Bills of Exchange Act 1882 C 61. Part Supplementary Document Generated 2024 to 0505 Changes to Legislation. There are currently no known outstanding effects. 89 Fahrenheit. A. Prevent the responsible banker claiming a contribution from any other person. Or B. Affect any remedy available to the responsible banker in contract or otherwise. 7. Except so far as regulations under the section provide expressly, nothing in the section or regulations under it is to be taken to affect any liability of the responsible banker which exists apart from this section or any such regulations. Supplementary. 1. Regulations under this part may A. Include incidental, supplementary, and consequential provision. B. Make transitory or transitional provision or savings. C. Make different provision for different cases or circumstances or for different purposes. D. Make provision subject to exceptions. 2. The power to make regulations under this part is exercisable by statutory instrument. 3. An instrument containing A. Regulations under Section 89A or 89D, or B. The first regulations to be made under Section 89E. May not be made unless a draft of the instrument has been laid before and approved by resolution of each House of Parliament. 4. An instrument containing any other regulations under Section 89E is subject to annulment in pursuance of a resolution of either House of Parliament. 5. For the purposes of this part, a banker collects payment of an instrument on behalf of a customer by A. Receiving payment of the instrument for the customer, or B. Receiving payment of the instrument for the banker, but not as holder, having I. Credited the customer's account with the amount of the instrument, or C. Otherwise given value to the customer in respect of the instrument. 6. Section 89E4 applies for the purposes of subsection 5 in its application to Section E Part V 5th Supplementary. 90% good faith. A thing is deemed to be done in good faith, within the meaning of this act, where it is in fact done honestly, whether it is done negligently or not. 91 signature. 1. Where by this act any instrument or writing is required to be signed by any person, it is not necessary that he should sign it with his own hand. But it is sufficient if his signature is written thereon by some other person by or under his authority. 2. In the case of a corporation, where by this act any instrument or writing is required to be signed, it is sufficient if the instrument or writing be sealed with the corporate seal. But nothing in this section shall be construed as requiring the bill or note of a corporation to be under seal. 90% 2% computation of time, where by this act the time limited for doing any act or thing is less than 3 days. In reckoning time, non-business days are excluded. Non-business days for the purposes of this act mean A. F28 Saturday, Sunday, Good Friday, Christmas Day. B. A bank holiday under F29, the M1 Banking and Financial Dealings Act 1971. C. A day appointed by royal proclamation as a public fast or Thanksgiving Day. F30D a day declared by an order under Section 2 of the Banking and Financial Dealings Act 1971 to be a non-business day. Any other day is a business day. Textual amendments F28 word inserted by Banking and Financial Dealings Act 1971 C80 S313 F. Words substituted by Banking and Financial Dealings Act 1971 C80 S44 F30 S92 added by Banking and Financial Dealings Act 1971 C80 S44. Marginal citations M 1971 Celsiuses. 80, 93 when noting equivalent to protest. For the purposes of this act, where a bill or note is required to be protested within a specified time or before some further proceeding is taken, it is sufficient that the bill has been noted for protest before the expiration of the specified time or the taking of the proceeding, and the formal protest may be extended at any time thereafter as of the date of the noting. 94 protests when notary not accessible. F31, where a dishonored bill or note is authorized or required to be protested, and the services of a notary cannot be obtained at the place where the bill is dishonored. Any householder or substantial resident of the place may, in the presence of 2 witnesses, give a certificate signed by them attesting the dishonor of the bill. And the certificate shall, in all respects, operate as if it were a formal protest of the bill. The form given in Schedule 1 to this act may be used with necessary modifications, and if used, shall be sufficient. Document generated 2024 to 05-5 changes to legislation. There are currently no known outstanding effects. For the Bills of Exchange Act 1882, see end of document for details. F32.2 in subsection 1, notary includes a person who, for the purposes of the legal. Services Act 2007 is an authorized person in relation to any activity which constitutes a notarial activity within the meaning of that act. Textual amendments F31S 94 renumbered January 1st, 2010 as S941 by legal. Services Act 2007 C29 S 2007. 21 para 10A with SS29 192 193 SI 2009 3250ths Art to HF32S 942 inserted January 1st, 2010 by Legal Services Act 2007 C29 in the enjoyable manner. 21 para 10B with SS 29 192 193 SI 2009 3250ths Art 2H 95 dividend warrants may be crossed. 96. The provisions of this act as to cross checks shall apply to a warrant for payment of dividend. F33. 97. Textual amendments F33S 96 CH 2 repealed by statute law revision Act 1898 C 22. Savings 1. The rules in bankruptcy relating to bills of exchange, promissory notes, and checks shall continue to apply thereto, notwithstanding anything in this act contained. 2. The rules of common law, including the law merchant, save insofar as they are inconsistent with the express provisions of this act, shall continue to apply to bills of exchange, promissory notes, and checks. 3. Nothing in this act or in any repeal effected thereby shall affect A. B. F. 34. Any law or enactment for the time being in force relating to the revenue, the provisions of the M2 Companies Act 1862 or acts amending it, or any act relating to joint stock banks or companies. C. The provisions of any act relating to or confirming the privileges of the Bank of England or the Bank of Ireland, respectively. D. The validity of any usage relating to dividend warrants or the endorsements thereof. Textual amendments F34 words repealed by statute law revision Act 1898C 22. Marginal citations M2 1862 Celsius 89 98. Saving of summary diligence in Scotland. Nothing in this act or in any repeal affected thereby shall extend or restrict or in any way alter or affect the law and practice in Scotland in regard to summary diligence. 99 construction with other acts A and C. Where any act or document refers to any enactment repealed by this act, the act or document shall be construed and shall operate as if it referred to the corresponding provisions of this act. 100% parole evidence allowed in certain judicial proceedings in Scotland. In any judicial proceeding in Scotland, any fact relating to a bill of exchange, bank check, or promissory note, which is relevant to any question of liability thereon, may be proved by parole evidence, provided that this enactment shall not in any way affect the existing law and practice whereby the party who is, according to the tenor of any bill of exchange, bank check, or promissory note, debtor to the holder in the amount thereof may be required as a condition of obtaining assistive diligence or suspension of a charge, or threatened charge, to make such consignation, or to find such caution as the court or judge before whom the cause is depending may require. F35. Textual amendments. F35 words repealed by prescription and limitation Scotland, Act 1973, C52, S 162, Shach, 5 PT. 41. Bills of Exchange, Act 1882 C 61. First scheduled document generated 2024-050, 5 changes to legislation. There are currently no known outstanding effects. Schedules. First schedule. Form of protest which may be used when the services of a notary cannot be obtained. Know all men that I, A.B., householder of in the county of in the United Kingdom, at the request of C.D., there being no notary public available, did on the day of 188 at demand payment or acceptance of the bill of exchange hereunder written from E.F., to which demand he made answer, state answer, if any, wherefore I now, in the presence of G.H. and J.K., do protest the said bill of exchange. Signed, Ab G.H. witnesses. J.K.N.B. The bill itself should be annexed or a copy of the bill, and all that is written thereon should be underwritten. F36 second schedule. Textual amendments. F36S 96 Sh 2 repealed by statute law revision Act 1898 C 22 F 36 42 Bills of Exchange Act 1882C. 61 document generated May 5th, 2024. Changes to legislation. There are currently no known outstanding effects for the Bills of Exchange Act 1882.
Mm.